according
to
to
out here,
the ranchers, it's,
fence line.
yeah. So you run, it's not always decided the way the law would have it decided. Particularly if if property owner A is like important in the community and property owner B is the Yankee who just moved in. So yeah, what I'm getting at is that yes, there are very clear rules, and then it goes to court. It's so common in court for a jury to decide based on whether they like you or whether they don't. And the same can be said for, we like that surveyor better than we like this surveyor, therefore we will decide on that basis. I'm not saying that it happens all the time, but when we get into the issue of the expert witness, God, the last thing you ever want to do as an expert witness is answer a question yes or no.
Isn't that what a lawyer tells you to do?
No, yeah, that's what he tells you to do, but that's what you should not ever do as an expert witness. You should be there to explain things. You should not be pinned down on details. So yeah, it's a frightening place, court. So. Okay, we got to 14, sort of. Possession may memorialize original survey lines, and as such may be the best or worst evidence of original lines. The fence, the road, and best available evidence is what you have when you can't find what you're looking for.
So what's the answer to your question?
Principle 13 or 14. I don't really have answers. I'm not supposed to, answer everything. If a court case is decided on the basis of possession and at a later date, original monuments are found undisturbed, what happens?
It goes back into court?
It can. It can go, there are, boundary by agreement. Works real well when everybody is nice and everybody signs the document. First off, it's got to be a document. Second off, it has to be signed, then it has to be recorded. Remember how I said if you have acquiescence between two parties where the position of the original line is unknown, does that bind the heirs and assigns? So, upon these two, or one of these two's death, the whole thing can go back into a state of total confusion. And there's nothing worse, nothing worse than having something like this happen when the two parties are cousins. Because it can start a family feud that will last for generations. If you're gonna get a boundary line by agreement between two parties, which, it's an order of magnitude cheaper to do that than it is to go to court. Make sure it's written down. Make sure it's written down, signed, notarized, filed. Because otherwise, it's just kicking the can down the road. And there's a prejudice against fence line surveyors because they just go in and record the location of the fences and don't necessarily look for original monumentation. Don't be one. It's just because a fence is there is no indication that that's where the actual boundary is. It might have been, you're driving around and you see the fence on the right of way, right? Then you see a fence that's like 20 feet over from that. so that the cattle in pasture A can graze contentedly away while the cattle from pasture B are herded into pasture C. It's just a fence of convenience. And by the way, where is the actual boundary of the tract? If you've got the right-of-way here, here, then you've got the fence 20 feet away, and you've got your neighbor here and your neighbor here. Where does the tract extend to?
What do you mean?
In all likelihood, if you've got a right-of-way here, a county road.
A county road?
Yeah, county road, or, you know, definitely not an interstate.
It'll go to the center line of the road?
The actual boundary of the tract usually goes, I mean, the title goes to the center of the road. Usage, I mean, it's everybody and his brother has the right to use the roadway as a roadway. They don't have the right to park a mobile home there for an extended period of time. They don't have the right to graze, you know, their own cattle. You know, like, the only person who has the right to do any grazing on the right-of-way is the owner of the property. If the property was actually purchased by the county or dedicated in fee to the county, that's different. But basically, it's assumed that the actual boundaries of the parcel go to the center of the road, and that the right-of-way is a boundary. You know, yes, it's there, but that only denotes the right of the public to use that roadway as a roadway. Should oil be discovered, fancy that in the Permian Basin, and someone sinks a hole in the right-of-way, who gets the oil, the proceeds?
Whoever owns the mineral.
Well, yeah. If the mineral rights haven't been separated from the land, the owner. That was a very important court case in like 1920s, very early 20s. It was called Rio Bravo v. Weed. And it had to do with a railroad right-of-way running through a subdivision. And this little quarter acre produced in 1920 $20 million worth of oil when it was very, very cheap. It was right near Spindletop. So someone poked a hole in the ground and all hell shot up. It was one of those incredible early wells that was just a mega producer. But the owner of the property owns to the center of the road. Okay.
Doesn't the railroad have their own right of way now? So back then
It all depends. It depends on how were they created, what act created those railroads. In other countries, in England for instance, the railroads had to buy the right-of-way, in which case they own the right-of-way. In Texas, for the most part, the right-of-way is an easement. And if the necessity for the easement goes away, i.e. the railroad goes out of business, and nobody picks up the pieces, then the owners can claim to the center. But it has, you know, the necessity, I mean, it has to not just cease operations, but it has to be, you know, like dedicated back, which is not usually the case with something going bankrupt. Someone always buys the pieces and then does something with it. But, and this has to do with easements. This is an aside. If you have a railroad right-of-way, it's kind of hard to say if you say it 2 or 3 times. If you have a railroad right-of-way, that's for the use of the railroad, right? What if you want to run a fiber optic cable all along your railroad right-of-way from one point to another. That's not railroad, is it? What about the income derived? What happens to it?
The what?
Income
Oh, the money?
derived from the fiber optic cable.
Run on the railroad line?
Hmm?
Run on the railroad
Running
line?
on the railroad right-of-way.
Inside of it?
Inside the railroad right-of-way.
It's split
Split what?
in between the owner and the railroad?
Well,
Because he still has the land, they just have the easement.
I don't think railroad
Where do you
lets
think
do
this one
anything
ended
under
up?
right away.
when all was said and done, where do you think that case ended up?
In court.
How high do you think it went?
Probably Supreme Court.
All the way to the top. And because Union, I think it was Union Pacific or Santa Fe. No, it was Santa Fe. Did not seek the permission of the adjoinders to run this fiber optic cable along the right of way. They ended up paying a massive amount of money in damages and basically what they should have paid to the owners of the property for the use of that property to run the cable. Because when Santa Fe, Atchison, Topeka, and Santa Fe got the easement to run their railroad right of way, they did not get fee simple title to that land. But it was only for the use of a railroad, not for the use of a fiber optic cable. That would have been like a telegraph line open to the public. The railroad is a common carrier for rail traffic, not for information traffic. So that was an entirely new and unauthorized use of that right of way. So that was something that we got thrown at us at the state convention. I was one of the woman who was talking about railroads, yeah. But anyway, that was an aside. That was definitely an aside. Principle 16, the magnitude of permissible uncertainty of measurements is always determined by a court's interpretation. Oh, 15, I forgot 15. An original monument found undisturbed is undisturbed usually expresses the intent of the parties of the conveyance, fixes that point as between the parties, and as such has no error in position. All restored monuments established by measurement have some errors in precision or in position. In other words, they can be challenged. Are the rules for setting a lost monument the same as the rules not just the rules, but the standards of precision? Are the standards of precision for setting, the position of a lost monument, are they as precise, more precise, or less precise than the original patent or the original PLSS survey? You understand what the question is asking?
Nope.
Okay. Original surveys that created the PLSS in a given territory based on your, like your baseline and principal meridian in a territory. They were pretty generous. You could be off by, like 3 or 4 chains in a township. Can you be that imprecise setting a lost corner? How precise do you have to be? Where would you look to find
Find what?
find the instructions for resetting a lost monument?
Where state regulations.
Let's just say we're in Kansas. where would you look to find the official regulations for resetting a lost monument? Not an obliterated one, because you don't need to pull out the rule books for that. You're looking for the regulations to reset a lost monument.
Is it federal or?
That's the question. I'm not asking you how to solve it. I'm asking you, where do you look first? And you've got a copy of it.
Rectangular system.
Well, rectangular system. There's actually a publication. It was, the Lost and Obliterated Monuments from the BLM. That's the first place you look to find what the rules are according to the feds. Okay. Then, because that gives you the, this is as precise as you need to be nowadays, right? Then you go to the local judicial system. You're in Kansas. Then you find out what the court cases say. So you've got two different means of doing it. What happens if you get sued for following the original BLM instructions, and it turns out later that someone locates the original monument, even though the original monument was like 347 feet off?
They're right. They're correct.
Who?
They are. The one that...
You're not helping!
The one that found the monument.
One that found the monument is correct. What about the guy who set it according to BLM specifications?
No, the monument. The monument. What do you call it?
If found undisturbed, controls.
Yeah.
Yeah. Okay. What happens to the guy who considered the monument lost? He didn't find it because he was looking 347 feet off.
How many feet can you look and be off?
Guess what? If you find the original monument and the jury believes you, 347 feet. How many chains is that, by the way?
5?
It's more than 5 and less than 6, because a chain is 66 feet. That it was a township corner, and it basically, in this case, it was going into BLM land. Yeah, and by reset, I'll read you the court case, or I'll read you Clark's interpretation of it. It's like 1992.
But 340 feet off. I mean, that's...
Yeah, would you look 340 feet off?
Wouldn't they give you an excess and too much acreage on one? And
Don't know. I don't know the all of the.
wouldn't they give you a big old bin on your...
It all depends. This one is
according
in
to
Montana.
Because he would, in order for him to say he was that lost monument, he'd have to come from a midpoint in a section, wouldn't he? Come across and put it?
Okay, I'll read you what I got. Okay? Although the manual and other documents prepared by the BLM are not binding on private surveyors, it is important that surveyors who practice in the General Land Office states have a firm and thorough understanding of what the BLM represents. An excellent example of this can be found in a 1992 Montana decision in which a surveyor completed a survey prior to a dependent resurvey. Remember what a dependent resurvey is? Okay, resurveys happen when the original, township plat is called into question drastically. And only a cadastral surveyor, blessed by the BLM, can perform one of these to relocate according to the information on the plat as best he can. The cadastral surveyor called on to do a dependent resurvey has to follow the calls of the original plat as best he can. Now, the private surveyor was under no such constraint, but he followed the rules of the BLM when he did his survey, right? Okay, that's the scenario. Upon completion of the BLM resurvey, after the private surveyor did his survey and located the corner the best he could, it was determined that an original corner recovered by the private surveyor was in error, and the original corner determined by the BLM was 374 feet different. So the private surveyor did his job right. The resurvey corrected the error. But the poor client of the private survey, that was called for, found that the land that he was buying based on this survey was intruding into federal, BLM land. He sued the surveyor. Okay, this resulted in an encroachment on public domain lands. The developer brought an action against the surveyor for negligence. The court determined that although the private surveyor did not recover the original corner, he had relied on the manual issued by the BLM and used the criteria of the best available evidence. The court held that the surveyor had met the acceptable standard of care required of a registered surveyor, and therefore there was no negligence.
Yeah, but how do they know that the BLM said it was supposed to be to begin with?
Because he gets to wear this little shirt that says cadastral surveyor. No, it's kind of like being an LSLS. If the LSLS says you have state land enclosed under fence, you have state land enclosed under fence, no matter what your private surveyor said. It's ranking. And the court, obviously the court went with the resurvey. That happened at a later date. The private surveyor followed the rules according to the BLM and was wrong by X number of feet on a line.
Sounds like politics to me.
No, basically, he followed best available evidence and he followed the manual.
The private surveyor did.
Yeah.
The BLM stuff was probably all politics.
No way of knowing. But we don't know the facts